Lord Chief Justice, distinguished members of the judiciary, members of the MacDermott family, distinguished guests and friends, my name is Robin Hickey. I'm the head of the School of Law here at Queen's, and on behalf of all of my colleagues, it's a tremendous pleasure to give you the warmest of welcomes to this especially significant event in the law school's annual calendar. Before we begin, let me give you the important news that we're not expecting to be interrupted by any fire alarms this evening. Should they sound, please leave your things behind and leave the room by one of the marked doors here. We go down the stairs and meet outside the front of the building at the assembly point. And should we find ourselves in this situation, please do not come back into the building until we are given the all clear by security. And with those matters in hand, this annual lecture is an event to honour Lord MacDermott and to reflect the continuing esteem in which he is held, a most distinguished alumnus of this place and a law teacher and judge of international standing. After service in the First World War, for which he was awarded the Military Cross, he enjoyed a successful academic career alongside a high-profile practice at the bar. Having taken silk in 1936 and a parliamentary seat in Northern Ireland in 1938, he was appointed Attorney General of Northern Ireland in 1941 and a High Court judge 3 years later. In 1947, he was appointed Lord of Appeal in Ordinary, and subsequently Baron MacDermott of Belmont returned to the bench in Northern Ireland as Lord Chief Justice in 1951, an office in which he served for 20 years with considerable distinction until his retirement. Here at Queen's, we take justifiable pride in this great legacy, and also in his wider contributions to the university as a lecturer in jurisprudence and as a Pro-Chancellor, and we continue to acknowledge and to celebrate a life of exemplary public service. This lecture series was inaugurated in 1972 to commemorate Lord MacDermott's retirement as Lord Chief Justice. As many of you will know, in framing this occasion, our custom is to return to Lord MacDermott's terms of reference for the series, delivered with characteristic rigour and clarity in that inaugural lecture in 1972, which he delivered. There, he made the following observation about the relationship between law and society and the importance of subjecting our key organising concepts to close scrutiny. And I quote from Lord MacDermott: "We know from the history of law and its institutions that the vitality and fortunes of a people are closely linked with the quality of their laws and can ebb and fail if these cease to be effectual or to serve the requirements of the society they purport to rule. And knowing that, it is only prudent that we should from time to time scrutinise the health and condition of our principal legal concepts and mark any trend or sign which might injure or imperil the common weal." Tonight we are honoured that this job of scrutiny will be undertaken by Sir Anthony Hart, whom we've been most fortunate to have here in the school as a visiting Professor of Law during the past academic year. It's my pleasure now to invite my colleague Norma Dawson, Professor Emeritus in the school, to introduce Tony. Norma.
Lord Chief Justice, members of the MacDermott family, Lady Hart, ladies and gentlemen, it gives me great pleasure to introduce our distinguished speaker. Our paths first crossed when I was a bar student in 1975-76, when Sir Anthony lectured on criminal procedure. It was one of those occasions when the skills of the lecturer vastly exceeded the aptitude of the student. But if criminal procedure did not provide common ground, in time legal history would do so, and for many years I have enjoyed his friendship in the Irish Legal History Society. Sir Anthony's legal career began as an undergraduate in Trinity College, Dublin. He was called to the Bar of Northern Ireland in 1969, and in 1975 he was called to the Bar of England and Wales by Gray's Inn. He took silk in 1983, and within 2 years he was appointed to the County Court bench. He became a bencher in 1995. He was Recorder of Londonderry and Recorder of Belfast successively from 1985 to 1990 and from 1997 to 2005, and was the presiding judge of the county courts for 3 years until 2005. In that year he was appointed to the High Court bench in Northern Ireland, and in that role he presided over many criminal trials. Sir Anthony was a founder member and first Northern Vice President of the Irish Legal History Society, established in 1988, and he served as President from 1991 for 3 years. Very few have made a greater contribution than he has to the Society's growth and influence. He is also a member of the Selden Society, the English Legal History Society, and through his regular participation in British legal history conferences, which are large international affairs, he has encouraged many young legal historians from across the world. He is currently involved in the planning of a joint British and Irish legal history conference to be held here at Queen's in 2021. He has also honoured us by accepting an honorary professorship in Queen's Law School. Sir Anthony's personal contribution to legal history scholarship will be enduring. Author of a history of the King's Sergeants at Law in Ireland, published in 2000, he also published a landmark history of the Bar and the Inn of Court of Northern Ireland in 2013. His work has been published in legal journals and in the Society's Collected Discourses series. He was awarded the Gold Medal of the Society for 2012. That year also marked his retirement from the High Court bench, but it is not entirely clear what definition of retirement guides him, for he then accepted appointment as chair of the Historical Institutional Abuse Inquiry, an inquiry the scale and scope of which made legal history in these islands. Those of us privileged to call him friend know him to be a deeply humane person, and so he was perfectly equipped to undertake such an important, harrowing, but one hopes ultimately redemptive role. The inquiry team's work covered the period 1922 to 1995 and led to the publication of a multi-volume report in January 2017. Despite the clarity of the report's findings of disturbing levels of institutional child abuse and the compelling force of the team's recommendations, the failure to date of government to implement the recommendations is lamentable, and in the context of abused children, now in middle age or old age, inexcusable. Sir Anthony's chosen subject for his MacDermott lecture, Public Inquiries, Their Role in Civic Society, Past, Present and Future, is one on which he can speak with a special authority. Ladies and gentlemen, Professor Sir Anthony Hart.
Professor Hickey, Professor Dawson, Norma, Sir John, ladies and gentlemen, it is a very great privilege to have been invited to deliver this lecture here tonight. I little thought when I came to Queen's University as a rather lazy Trinity undergraduate or recent graduate nearly 50 years ago that I'd be standing here delivering a MacDermott lecture. It is a particular honour to have been asked and a very great privilege to be able to do so, particularly in the presence of members of the MacDermott family and Sir John, who was not only, of course, an extremely distinguished and remarkably helpful, very senior colleague when I was on the bench, but I have the pleasure in rather belatedly acknowledging the many kindnesses he showed to me as a very young barrister in a very much smaller bar library as it was then, trying to find my feet in the first days and weeks of my time at the bar. As you will hear, both Sir John and Lord MacDermott themselves had some experience of appearing in public inquiries, and I hope what I'm about to say, therefore, will not meet with criticism from that quarter. But it would be tempting to engage in a survey of the nuts and bolts of inquiries, and I'm going to try and avoid that as much as I can tonight, because there is, I think, a certain reluctance to examine just how public inquiries work. They have become a great feature of our modern society. But this is not a completely recent development, because for centuries the United Kingdom has resorted to various mechanisms to publicly investigate matters where there has been widespread concern that serious maladministration or malpractice has occurred, on the part of central or local government, public or private organizations. Those countries which have a common legal and political history with the United Kingdom, such as Ireland, Australia and Canada, only to mention some, have resorted to similar mechanisms on many occasions. Time does not permit more than a passing reference to some of these jurisdictions this evening, but such mechanisms have been employed in matters of the utmost legal and political significance. For example, the Flood and Mahon inquiry into allegations of planning corruption in the Irish Republic, and the recent Royal Commission into institutional responses to child sexual abuse in Australia. As the late Professor Keaton showed in his trial by tribunal, the initial process can be traced back to the establishment by the House of Commons in 1667 of a committee to investigate how Charles II and his ministers spent taxes voted by Parliament. Such parliamentary committees of inquiry remained a significant feature of British public life for more than 250 years. Some of you may be familiar from his diary with the Committee of Inquiry into Miscarriages of the Navy appointed in 1679, which was designed to destroy the great diarist and servant of the Navy, Samuel Pepys, and damage his master, the Duke of York, later James II. And they continued up until the Marconi Inquiry of moderately more recent times of 1912 and 1913. These and many similar inquiries were characterized by highly partisan motives on the part of members of the parliamentary committees, and as Professor Keaton convincingly argued, the rancor of party politics prevented such inquiries from being an impartial determination of the facts in a matter of major public importance. It was in the 19th century that we see the first signs of the emergence of a recognizable independent judicial form of investigation in the shape of inquiries into the loss of vessels, often with very heavy loss of life, under successive merchant shipping acts. For example, between October 1876 and the end of 1883, 402 such inquiries were conducted by wreck commissioners, lawyers assisted by assessors with nautical experience. These ranged far and wide, both in geographical and other terms, from, for example, the inquiry into the loss of the Eagle Speed in the Bay of Bengal in August 1865, with the loss of no European lives, but 329 Indian native lives, to the loss of the German steamship Deutschland in December 1875, which inspired Gerard Manley Hopkins to write his poem, The Wreck of the Deutschland. Many other tragic losses at sea have been investigated under later merchant shipping acts, such as the loss of the Princess Victoria off the County Down coast in January 1953. And indeed, 4 such inquiries have been held under the 1995 Merchant Shipping Act, the last being the inquiry announced in October 2009 into the loss of the fishing vessel Trident. Until 1921, in general matters of public concern relating to a specific episode or series of related episodes were investigated under prerogative powers by what were in all but name royal commissions appointed by government. And in this part of the world we find 3 such inquiries in the 1860s and the 1870s. The Belfast Inquiry of 1864, the Londonderry Inquiry of 1869, and the Dungannon Inquiry of 1871. The Belfast and Londonderry inquiries were into riots, part of our sad and repetitive history in that area, but resulted in the disbandment of the local constabularies in both cities. The Dungannon Inquiry related to allegations of partiality in the administration of justice by the local magistrates and police. Each of these inquiries was established by a warrant from the Lord Lieutenant of Ireland, or in his absence the Lord Justices, and were conducted by 2 prominent Irish QCs, variously described as a court of inquiry or a commission. The commissioners sat in public, but had no power to summon witnesses or compel the production of documents. However, parties representing different interests were legally represented. Witnesses were requested to attend by the commissioners, some of whom were suggested by the parties, and the witnesses were then examined and cross-examined by counsel or solicitors for the parties. These inquiries were all both extensive in scope and rapidly carried out. For example, the Belfast Inquiry of 1864 started 11 days after the warrant was issued, lasted 22 days, and examined 127 witnesses. My colleagues on the panel and from the HIA inquiry can smile at that. However, the absence of statutory powers was a significant weakness of such non-statutory inquiries, and that was demonstrated in 1886 when the Belfast Riot Commission, yet another riot commission, was established in the same fashion to investigate the severe rioting that occurred throughout the city over a period of some months in the aftermath of the collapse of Gladstone's Liberal government following the defeat of the first Home Rule Bill. 4 commissioners were initially appointed, 2 of whom were lawyers, but the chairman was Sir Edward Bulwer, who was a distinguished soldier and deputy adjutant at the War Office at the time. However, it's clear from the initial day's hearings that Bulwer was completely unable to control the proceedings, and the rioting indeed continued after that for some time. This led Parliament on the 25th of September of that year to pass the Belfast Commission Act, the preamble stating that, and I quote, "The powers for the effectual conducting of such an inquiry cannot be conferred without the authority of Parliament." Under the Act, Mr. Justice Day, who is a judge of the English High Court, was appointed as an additional member and chairman of the inquiry, and the inquiry was given all the powers of the High Court in Ireland to enforce the attendance of witnesses, compel the production of documents, and punish for contempt. And false evidence on oath was perjury. It was soon followed by the Special Commission Act of 1888, which set up what is generally known as the Parnell Commission. That consisted of 3 judges, one of whom is Mr. Justice Day, and had conferred upon it more explicitly defined powers, and it is often regarded as the first modern statutory inquiry. But I think it can be argued that the distinction can be more appropriately attributed to its predecessor in 1886. Curiously, despite the precedent of these 2 commissions, the statutory model of inquiry was not resorted to again until the Special Commissions Dardanelles and Mesopotamia Act of 1916. Both had powers to compel the attendance of witnesses and the production of documents, and to commit for contempt, powers that were comparable to those of the 1886 and 1888 Acts. However, despite these precedents from the 1880s, at that time the non-statutory form of inquiry continued to be resorted to. As we've already noted, the Marconi scandal of 1912 was the subject of a parliamentary committee of inquiry, and in Ireland the non-statutory or prerogative model was resorted to in 1914 and again in 1916. In 1914, a commission of 2 serving and 1 retired judge inquired into the shooting dead of 3 people and the wounding of at least 38 others by members of the King's Own Scottish Borderers, who had been stoned and taunted by a crowd as the troops were marching back to barracks along Bachelor's Walk in Dublin. They had been called out to assist members of the unarmed Dublin Metropolitan Police who were attempting to seize weapons being landed at Howth by the Irish volunteers. In 1916, the Home Secretary of the day set up another Royal Commission this time chaired by Sir John Simon, KC MP, who is a recent but former Liberal Home Secretary, Lord Justice Maloney, who, as Mr. Justice Maloney, had served in the 1914 Commission, and Dennis Henry, KC, who was some years later to become our first Lord Chief Justice. Their remit was to inquire into the arrest and subsequent treatment of Francis Sheehy Skeffington, Thomas Dixon and Patrick McIntyre, who were shot dead in Dublin on the 25th of April 1916 in the aftermath of the rebellion on the orders of Captain Bowen Colthurst. Both these inquiries were forthright in their findings. That of 1914 described the attempt to seize the weapons at Howth as tainted by fundamental illegality, and the use of firearms as unjustified and indiscriminate. The 1916 inquiry said, the shooting of unresisting civilians without trial constitutes the offence of murder, whether martial law has been proclaimed or not. Both sat in public, and in contrast to the earlier non-statutory inquiries, despite the precedent of the Preamble of the 1886 Act, were given authority to summon witnesses and order production of documents, and again they allowed interested parties legal representation and the right of cross-examination. Now, I have referred to these non-statutory or prerogative inquiries, as I call them, in some detail because, despite their evident procedural limitations, as we shall see, they continue to be set up today. However, the Tribunal and Inquiries Evidence Act 1921 created the first non-specific format for public inquiries and remained in force in this jurisdiction until replaced by the Inquiries Act 2005, despite some of its deficiencies being identified by the Royal Commission on Tribunals of Inquiry of 1966, chaired by Lord Justice Salmon. The 1921 Act made provision for all inquiries in the future and provided that an inquiry could only be instituted by either the Sovereign or a Secretary of State when both houses had resolved that a tribunal be established for inquiring into a matter described in the resolution as of urgent public importance. The public were entitled to be present, as of course they were in the prerogative inquiries that I have described, and the tribunal had all the powers of the High Court, powers to summon witnesses, compel production of documents, enforce the attendance of witnesses, of course, but including the unusual power to examine witnesses abroad. Such was the scope of the empire in those days. And it gave witnesses the same privileges and immunity as witnesses before the High Court. But although these powers appeared extensive, as the Salmon Commission was to point out in 1966, no provision was made for the provision or for the procedure to be followed by the inquiry, nor, somewhat surprisingly, did the Act confer immunity on members of the inquiry for what they said during the inquiry or in the report, or on legal representatives for what they said during the inquiry. That doesn't seem to have been a problem, probably because it was then a more deferential age than it is now. The 1921 Act was significantly less comprehensive than the 1888 Special Commission Act, for example, and as Jason Beer, QC, has pointed out, it did not allow parties to inspect documents in the hands of other parties or to cross-examine witnesses. One provision that has not attracted a great deal of attention was the requirement that the inquiry could only be set up on foot of a resolution that satisfied both houses of Parliament that the matter to be investigated was of urgent public importance. To what extent this restrictive provision may have had in preventing some possible inquiries from being set up may merit further examination. And certainly during our own HIA inquiry, we found that in 1983, officials in the Northern Ireland Office were concerned that allegations relating to Kincora may not have been regarded as being of sufficient national as opposed to purely local or Northern Ireland importance to justify a 1921 Act inquiry. And that was because Salmon had said that inquiries under the Act should only be for matters of national importance. So what was going on in Northern Ireland wasn't thought to be of national importance. Until 2005, 24 inquiries only were conducted in the United Kingdom under the 1921 Act, 7 into allegations of corruption or financial mismanagement, 6 into loss of life, including the Aberfan, Widgery and Savile inquiries, 5 into allegations of police malpractice, and the Waterhouse inquiry into abuse of children in care in North Wales. The other 5 covered a range of matters, including, for example, the 1962 Vassal inquiry into espionage. Curiously, the list includes the 1924 Royal Commission on Lunacy and Mental Disorder, which was, in fact, as the title would indicate, a conventional royal commission, but for some reason they utilized the 1921 Act. It should not, however, be assumed that the 1921 Act was the only mechanism for statutory public inquiries. And between 1921 and 1966, there were 3 public inquiries of note in Northern Ireland into aspects of the functions of the then Belfast Corporation. 2 of these related to allegations either of corruption or certainly dubious practice in the housing area of the corporation's responsibilities. The McGaw Inquiry of 1925-26 was set up under the Local Government Ireland Act of 1872, and the Lowry Inquiry, which reported in 1962, was set up under the Public Health Ireland Act 1878. As the names of the chairmen suggest, both were conducted by distinguished counsel who later became High Court judge and, of course, in Lord Lowry's case, ultimately Lord Chief Justice and a Lord of Appeal in Ordinary. Again, as was entirely customary by this stage, they were held in public, having legal representation and being permitted to cross-examine witnesses. And I hope I'll be forgiven for pointing out that in the McGaw inquiry, Clerk MacDermott, as he then was, later Lord MacDermott, appeared for some of the interested parties, and Sir John was the junior counsel to the Attorney General in the Lowry inquiry of 1962. Not quite as old as that. But the third Northern Ireland inquiry I'd like to mention is noteworthy as an unusual form of public inquiry and because of its significant contribution to the improvement of public health in Northern Ireland. In 1940 and 1941, the White Abbey Hospital inquiry examined matters relating to what was then known as White Abbey Tuberculosis Hospital, which was the responsibility of Belfast Corporation under the Tuberculosis Prevention Ireland Act of 1908. In order to allow the inquiry to take place, the Stormont Parliament passed the Local Government Inquiries Act Northern Ireland 1940, and also to enable the inquiry to utilise earlier powers under the Public Health Act of 1878. It was not conducted by a judicial figure, it was conducted by a civil servant from the Ministry of Home Affairs, assisted by a colleague who was a doctor. The Attorney General assisted the inquiry by opening it and calling the witnesses. Legal representation was allowed and extensive cross-examination and closing submissions can be found in the 3-volume transcript of the evidence. However, there was not a report published in the conventional way that we were and still are used to. And what happened was in June 1941, not long after the terrible blitz on Belfast, the Ministry of Home Affairs issued a lengthy letter to the Lord Mayor of Belfast, quoting verbatim passages from the Inspector's report to the Ministry interspersed with the Ministry's conclusions and the action it proposed to take. The action was drastic and immediate. Several staff were sacked. The corporation was immediately stripped of its responsibility for tuberculosis prevention, and 3 commissioners were appointed to run the hospital. The next year, 1942, the Belfast County Borough Administration Act, Northern Ireland, was passed by Stormont, and 3 administrators were given complete control of the staff, finances, and administration of the corporation, which existed in a sort of shadowy form, but in effect was completely superseded as an elected body for the remainder, or much of the remainder of the Second World War. As Professor Greta Jones pointed out, since the bulk of TB sufferers and TB services were situated in Belfast, and as White Abbey was the largest sanatorium in Northern Ireland, this meant that the commissioners who had been appointed to run the hospital virtually assumed responsibility for TB policy in Northern Ireland as a whole. And although the 1941 report was not by any means solely responsible for what happened afterwards, it can, I think, be reasonably described as a critical turning point in the provision of TB services. And as Professor Jones points out, these services were to play a vital part in the elimination of the TB epidemic, because such it was in the province. Before the 1966 Royal Commission report was issued, 16 1921 acts had been, act inquiries had been held. And the Salmon report was an extremely thorough and comprehensive survey of the inquiries to date, that is, under the 1921 Act. And some of its observations are still relevant today, particularly the need for inquiries to be held in public to command public acceptance and credibility. Salmon reaffirmed the well-established principle that the powers conferred on inquiries under the 1921 Act were inquisitorial, and accepted that there was a requirement for, as it was stated, some permanent form of inquisitorial machinery without the necessity of recourse to legislation at the time, when there is something in the nature of a nationwide crisis of confidence. And it was that provision which was the limiting provision that worried the civil servants, as I've said, in 1983 in relation to Concora. The report's recommendations reflected the type of inquiries that had been held under the 1921 Act, and Lord Justice Salmon propounded what he described as the 6 cardinal principles, and the report declared, "We consider it to be of the highest importance that the 6 cardinal principles should always be strictly observed." Given that exhortation that the principles should always be strictly observed, it is not surprising that they were generally treated as being immutable, with the result that subsequent 1921 Act inquiries were generally conducted in an adversarial fashion, more appropriate for inter partes litigation, where the resolution of interests and matters at stake are defined by pleadings. However, in the 1990s, a number of inquiry chairmen started to question many of the Salmon principles and whether they should be followed to the letter. Not least the late Sir Louis Blom Cooper QC in the Ashworth Hospital inquiry he chaired in 1991 and 1992. Sir Richard Scott, as he was then, who conducted the non-statutory arms to Iraq public inquiry, critically analysed all 6 of the Salmon principles in his seminal 1995 lecture, Procedures at Inquiries, the Duty to be Fair, and explained the way his inquiry departed from them, particularly in respect of cross-examination. Time does not permit a discussion of all the Salmon principles, and this evening I want to confine myself to one, that is legal representation and the associated right of cross-examination. That is an issue which still raises its head today whenever inquiry procedure is debated. As Scott rightly emphasized, a witness in an inquiry does not have a case to propound, but evidence to give. All questions are to establish the truth of the matter under investigation and should not be designed to prove or disprove a case, as is the case when it is an adversarial form of litigation or inquiry. It must flow from this that the sixth and final salmon principle, namely that a witness should have the opportunity of testing by cross-examination conducted by his own solicitor or counsel any evidence which may affect him, is far too broad. My own experience in the HIA inquiry leaves me in no doubt that Scott was correct when he commented that the proposition of an automatic right of cross-examination was an unnecessary implant from proceedings designed for adversarial proceedings, and which would be likely in many inquiries to be wholly inimical to and perhaps destructive of the efficient conduct of the inquiry. Other doubts as to the universal applicability of cross-examination as a desirable method of establishing the relevant facts during a public inquiry were also expressed by Mr. Justice Frank Murphy in the Irish Supreme Court in 1999, albeit in the specific context of Irish constitutional law. In Lawler against Flood, he stated that the need for rights in determinative proceedings differs from those which have no such consequence, and that some of the rights long associated with adversarial proceedings do not translate into those of an inquisitorial nature. One of such rights associated with adversarial proceedings was the entitlement of a witness to cross-examine or have examined any other witness who gave evidence against him. He observed that to impose such an inquiry would involve the assumption that cross-examination is the only means or the only appropriate means of eliciting the truth. Such an assumption would place an excessive value on the adversarial system and implicitly reject alternative systems which find favor in other jurisdictions and appear to achieve an equally high standard of truth and justice. Cross-examination and legal representation are inextricably linked. And in 2015, our Court of Appeal held in BP's application, in relation to our own inquiry, that there was no overriding, all-inclusive principle that everyone giving evidence was entitled to such representation. Lord Justice Girvan pointed out that procedural fairness may not require separate representation, the cost of which, if applied generally, would be very significant, and the effect of which would be likely to increase the duration of the inquiry and would be likely to encourage the proliferation of side issues. I should emphasize, I do not question the need for publicly funded legal representation at public inquiries in certain circumstances, rather that it should only be allowed in limited circumstances, as was the case in the HIA inquiry. Another highly important development at this time was the adoption of the truly inquisitorial procedure pioneered between 1998 and 2001 by Sir Ian Kennedy, as he became, in the inquiry held under the National Health Service Act of 1977 into children's heart surgery at the Bristol Royal Infirmary. All questioning was carried out by inquiry counsel, but with counsel for relevant parties having the opportunity to liaise with inquiry counsel to ensure that all lines of examination were pursued and questions put. This approach has been adopted both by our HIA inquiry and by the Renewable Heat Incentive inquiry, And I echo Sir Ian Kennedy when he said in respect of his inquiry, the procedure worked with such success, not least due to the cooperation of all concerned, that in the event no application was made to cross-examine throughout the hearings. This procedure, when sensitively and skillfully performed by inquiry counsel, saves time and expense and should ensure that the questioning is conducted calmly and without rancour. Those who argue for a universal right to legal representation with the associated right to cross-examine fail to demonstrate what the benefit to the work of an inquiry such representation confers, as well as avoiding mention of the costs of such representation. Cost is a matter of legitimate public concern, as can be seen from the attention paid to the cost of the Savile inquiry into the events of Bloody Sunday. When the inquiry report was published, its total cost at that stage was initially stated to be approximately £192 million, of which 99.7 million were related to legal representation. No doubt the cost of that inquiry was an important factor in the Labour government's decision to introduce the Inquiries Act of 2005, which expressly requires the chairman to act with fairness and with regard also to the need to avoid any unnecessary cost, whether to public funds or to witnesses or others. The 2005 Act and its attendant 2006 rules provide for the first time potentially a truly comprehensive statutory code for the conduct of virtually all public inquiries throughout the United Kingdom, because it repealed the 1921 Act and many of the miscellaneous statutory provisions that hitherto applied to inquiries conducted under various statutes. I say potentially a truly comprehensive statutory code because, as those concerned with the RHI inquiry have discovered, no rules have been made under Section 41 of the Act for inquiries instituted by the devolved administration in Northern Ireland. The 2005 Act and the 2006 rules give statutory force to many principles and practices that had been developed, including the fundamental principle now embodied in Section 2.1 of the Act, that an inquiry panel is not to rule on and has no power to determine any person's civil or criminal liability. This gives statutory force to the common law principle propounded by decisions of courts in Canada, and notably in Australia in 1982, in Victoria against Australian Building Construction Employees and Building Labourers Federation. The Victoria decision was followed in the Republic of Ireland by the Supreme Court in Goodman International against Hamilton. That principle has, however, to be read in conjunction with that contained in Section 2, subsection 2, which states the equally fundamental principle that an inquiry panel is not to be inhibited in the discharge of its functions by any likelihood of liability being inferred from facts that it determines or recommendations that it makes. If that were not the case, then inquiries would be hamstrung and prevented from performing their function of establishing facts and reporting to government. The outworkings of the 2005 Act and the law in this area have attracted considerable attention in recent years, not least in public inquiries by Jason Beer, QC, and other contributors, including our own Joseph Aiken, Junior Counsel to the HIA and RHI inquiries. Although I think the second edition hasn't yet appeared, Joseph, is it correct? The 2017 report entitled How Public Inquiries Can Lead to Change, published by the Institute for Government, and the 2018 report Investigation into Government-Funded Inquiries from the National Audit Office have analysed the nature and cost of modern inquiries. The 2017 report initially identified 68 inquiries between 1990 and 2017, 69 when one includes the hypnonatremia inquiry. 22 of those were non-statutory, and it's significant that of the 29 established since the 2005 Act was passed, only 5 inquiries have been non-statutory. The range of matters investigated by public inquiries in recent decades is striking, covering occurrences as diverse as the 167 deaths on the Piper Alpha oil platform of July 1988, the deaths from outbreaks of E. coli in South Wales in 2005, up to the present-day inquiries investigating delays, cost overruns, and under-delivery in the Edinburgh Trams project, and, of course, the Grenfell Tower tragedy. The number and scope of the many statutory and non-statutory inquiries throughout the United Kingdom is proof, if proof be needed, that public inquiries continue to play a vitally important function in our democratic system, providing an independent, impartial, and thorough process to establish the facts of matters of real public concern and to make recommendations relating to the circumstances giving rise to the inquiry. That is not to say that public inquiries solve every problem. For example, there can be significant inconsistencies in the terms of reference of similar inquiries, such as in the case of the various inquiries into child abuse. The terms of reference of the HIA inquiry covered all forms of abuse in children's residential homes in Northern Ireland, and the present Scottish inquiry into abuse of children in care does so as well. But the independent inquiry into child sexual abuse in England and Wales is not as wide because, as its title indicates, it's only concerned with sexual abuse. And those who have read the dreadfully dispiriting descriptions of what happens at these various tribunals know that what happens to children in care and other forms of care other than institutional care doesn't just stop with sexual abuse. Emotional, physical, and other forms of abuse are at least as important, if not in some circumstances more so. Different types of inquiry are often set up in different parts of the United Kingdom to investigate the same subjects, but in different ways. For example, there were no fewer than 6 inquiries investigating outbreaks of C. difficile across the United Kingdom, including the Hine report into the outbreak in Northern Trust hospitals in Northern Ireland. It is interesting that the Academy of Medical Royal Colleges in Scotland has pointed out that in 4 of the reports it considered, 3 of which were in Scotland, and the 4th was the Mid-Staffordshire inquiry, also a C. difficile inquiry, there was a general failure in the reports to refer to the lessons learned from earlier reviews and reports. No discussion of public inquiries at the present day can avoid 2 recurrent criticisms: the length of time which inquiries take and their cost. Most of that criticism, I would argue, is misplaced. So far as the length of inquiries is concerned, every inquiry has to identify what work is necessary to fulfill its terms of reference, recruit the necessary staff, and establish processes for identifying and obtaining relevant evidence. Nowadays, that almost always requires specialist IT systems to be developed and put in place to store and access masses of documents, hundreds of thousands of documents very often, which then require to be collated and analyzed before the public hearings can start. Predictions by ministers as to how long an inquiry will take when announcing an inquiry are almost invariably wholly inaccurate and positively unhelpful. Once all the preliminary steps have been taken, then the public hearings can start, and their length will be determined by the complexity of the subject matter of the inquiry, and that in turn dictates the number of witnesses and the amount of documentation to be considered. I believe our HIA inquiry was unique as a public inquiry in being required to operate within a statutory time frame, although there was provision in our terms of reference to request an extension, and the terms stated that an extension will be granted provided it is not unreasonable. Because it became apparent to us that we could not call as witnesses all the residents of institutions within our remit who wished to give evidence within the 2.5 years allowed to us for our investigations, we successfully sought an extension of 1 year to that part of our timetable. I would maintain that it is only when public hearings have been completed that it is reasonable to calculate when the report should be delivered. In our case, we were obliged by our terms of reference to deliver our report within 6 months of the conclusion of the investigative phase, and although we managed to do so, it was an extremely challenging process for all concerned, and one to which our staff rose magnificently. This is an example of how difficult, if not impossible, it is to predict in advance how long will be required to conduct an inquiry and produce any report. Attempts to do so are almost certain to fail, and statutory time limits could all too easily be utilized as a means of restricting the work of an inquiry which was felt to be politically embarrassing. Nevertheless, although some further gathering and consideration of evidence may be necessary after the public hearings have concluded, I think it is reasonable in most cases to expect that the report can be delivered within 9 months from the conclusion of the public hearings, although a statutory requirement to do so would be unjustified because the scope of public inquiries can vary considerably, and the possibility of other factors such as illness or personal factors affecting the chairman, for example, cannot be excluded. The cost of inquiries is another area of frequent criticism. The Institute for Government report stated that since 1990, central and local governments have spent at least £638.9 million in 2017 terms on 68 public inquiries. The National Audit Office report gives the total cost of 26 government-funded inquiries established and concluded since 2005 as more than £239 million. There are, however, significant variations in the costs of inquiries, although it is not always apparent from the published information to establish whether the global figure for each inquiry in these reports includes the cost of participants not directly met by the inquiry, such as the costs of central or local government agencies or departments. Such costs are not always available, but can be considerable. For example, let us take the Edinburgh Tram inquiry. This was set up as a non-statutory inquiry chaired by Lord Hardy, a retired senator of the College of Justice in Scotland, and it was turned into a 2005 Act inquiry on his advice. In August 2015, Edinburgh City Council was reported to be expecting to spend up to £2 million participating in the inquiry. Despite the existence of the 2005 Act, as I indicated earlier, the non-statutory inquiry has not disappeared from the scene. An obvious example being the Chilcot inquiry into the actions of government and others in the run-up to the Iraq War. 5 other non-statutory inquiries have been set up by government in recent years. Described as independent panels, these have common features in that they have no powers to summon witnesses or to compel the production of documents, and most important of all, do not sit in public. Their purpose is to gather information and put relevant documents into the public domain, as in the Hillsborough Independent Panel in respect of the Hillsborough Stadium disaster of the 15th of April 1989, and the Gosport independent panel in respect of the care of older patients in Gosport War Memorial Hospital. Presumably, the minister who sets up such inquiries relies on the royal prerogative to do so, although in none of the panels I have so far examined is there any reference to any such power, as opposed to simply the decision of the minister concerned. The number of members of such panels is larger than in conventional public inquiries, and the expertise of members, the terms of reference, and the processes resemble those of past royal commissions. Yet, taking the report of the Gosport panel as an example, its conclusions are reminiscent of those of a statutory public inquiry, such as the reference in the foreword to there being, and I quote, a disregard for human life and a culture of shortening the lives of a large number of patients by administering and prescribing dangerous doses of a hazardous combination of medication not clinically indicated or justified. Whatever advantages such panels may have over conventional public inquiries, and the Hillsborough panel was, quote, set up deliberately and distinctly from an inquiry, expedition and cost are not necessarily some of them. The Gosport panel was announced in July 2014 and delivered its report in July 2018 at a reported cost of £14 million. The Daniel Morgan Independent Panel was set up in May 2013 and is yet to report, having cost almost £9.6 million up to the end of 2018. The limitations, as I would argue them to be, of such independent panel inquiries are graphically demonstrated by the genesis of the independent inquiry into child sexual abuse, which I've already mentioned. When it was announced in 2014, the Home Secretary of the day described it as, and I use her words, a non-statutory panel inquiry, consisting of an independent inquiry panel of experts in the law and child protection. However, in February 2015, the inquiry was reconstituted as a 2005 Act inquiry with a new and substantially smaller panel. This was principally because, as the same Home Secretary admitted, the other option of a Royal Commission, and I quote, would not have the same clarity over its powers to compel witnesses to give evidence. So although Parliament had recognised that deficiency as long ago as the 1886 Belfast Inquiry Act, it had been forgotten or unrecognised by the Home Office in 2014. Independent panel inquiries, by their nature and from the language used in their terms of reference, appear to be a form of non-statutory inquiry conducted outside the processes and protections of the 2005 Act. Only time will tell whether they survive or will be regarded as an acceptable form of inquiry into specific events. Well, what of the future for public statutory inquiries? Whilst the provisions of the 2005 Act and its rules are, I believe, broadly satisfactory, there are some provisions that could be re-examined. One is the controversial requirement in the Act for the inquiry to issue warning letters, and closely related is the non-statutory practice known as maximalisation. This is the opportunity given to those who will be criticised in the report to make what are almost always further representations before the report is published. The touchstone of fairness in every inquiry obviously demands that anyone who did not give evidence to the inquiry should have such an opportunity, but need those who have already had that opportunity during the inquiry have another opportunity. There can be no doubt that such an opportunity is not required at common law, as is clear from the decisions of the Court of Appeal in Ray Pergamon Press and the House of Lords in Hoffman de la Roche. However, the practice is widespread. Indeed, it's often described as being standard and often claimed to have appreciably extended the time taken to produce inquiry reports. Nevertheless, it may be argued in favour of maximalisation that it is one thing to have various criticisms put to an individual about their conduct or that of the organisation they now represent in a balanced, inquisitorial, non-judgmental form of question, and another to face a specific conclusion in the subsequent report that may have grave implications for the reputation of the individual or organisation concerned. Another practical justification for such a process is it provides the opportunity for participants to point out errors of fact or misapprehensions, and in the HIA inquiry we found that a useful process, and it was one also adopted by Sir Richard Scott in the Arms to Iraq inquiry. I believe that although the provision of relevant passages of draft criticisms can be a significant task for an inquiry team, it need not significantly extend the time required for completion and publication of the report if the inquiry gives a short time to those concerned to comment, whether it be a few days, as has been suggested on some occasions, or weeks, provided that the inquiry gives everyone notice of the process in advance and robustly operates the time limits it has set. In the HIA inquiry, we allowed between 2 and 4 weeks, depending on the length of the passages and the amount of material referred therein to be considered. Another provision of the 2005 Act that should be examined is Section 23, which places the responsibility upon the Minister to publish the inquiry report, although he can invite the inquiry chairman to do so. During the legislative process to set up our inquiry, which went through the Northern Ireland Assembly, there were calls that publication should be my responsibility. I had no objection to that, nor had my colleagues, and such an inquiry was included in the statute under which we operated, the Inquiry into Historical Institutional Abuse Act, Northern Ireland 2013. I'm satisfied from our experience that that is the right course, and I suggest that to allay suggestions, whether they're well-founded or not, that ministers are attempting in some way to alter or delete portions of a report. And in order to ensure in those circumstances, in the context of intense public suspicion, which so often surrounds the subject of an inquiry, that in order to ensure public confidence in the independence of the inquiry, the 2005 Act should be amended to make the chairman responsible for publication, subject only to the requirement that the minister receives the report for publication before publication in order to allow time for a public response to be prepared. Our inquiry was required to deliver the report to the then First and Deputy First Minister at least 14 days before publication, and we did so. Unfortunately, as is well known, the resignation of the late Martin McGuinness as Deputy First Minister on the Monday after the Friday afternoon or Friday evening when we delivered our report meant that the Northern Ireland Executive collapsed without responding to our recommendations. I believe 14 days notice to government is quite sufficient, and certainly it compares with the 12 weeks that elapsed between the delivery to government and the publication by government of the Saville report. If government wishes to argue that an inquiry report exceeds its terms of reference or infringes the limits set in Section 25, subsection 5 and subsection 6 of the 2005 Act, such as not withholding material that it is suggested may damage national security or international relations, then government should be able to apply to the High Court for an injunction, thereby ensuring that a judicial and not a political decision will decide such questions. If I may conclude with the the remarks of Lord Bingham in the surprisingly unreported decision of Crampton versus the Secretary of State for Health. Inquiries should culminate in full, fair, fearless, independent and objective reports covering all matters of concern falling within the terms of reference. In this necessarily brief survey of public inquiries over, I'm afraid, a very long period of time, I hope I have demonstrated that they have played and continue to play that crucial role in our civic society by providing an impartial and independent mechanism for establishing the true facts of important matters of grave public concern. Thank you very much.